Hello everyone, this is Tom Fox and I'd like to welcome you to episode 102 of the FCPA Compliance and Ethics Report. In this episode I visit with Bruce Carton, the founder and editor of securitiesdocket.com. We talk about his recent event, Securities Enforcement Forum, held in Washington, D.C. He talks about some of the panels, some of the key concepts and ideas that were talked about, and he talks about the administrative law proceedings through the SEC. The episode is about 25 minutes. I hope you enjoy it. Thank you. Hello everyone, this is Tom Fox and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. It is my distinct pleasure and privilege to have back my good friend Bruce Carton. Bruce is the founder and editor of Securities Docket, one of the top resources for all things securities law related in the United States. It is a fabulous resource which is available to the compliance, SEC, legal, or anyone else practitioner who's interested in things that relate in any way, shape, or form to the SEC. I asked Bruce if he could visit with me today because he just concluded earlier this month his signature event, or at least I think it's a signature event, because he puts on many during the year, but he had a Securities Docket conference in Washington, D.C., and in this event, he brings together really the creme de la creme of both the regulatory body of the Securities and Exchange Commission and white-collar defense practitioners and other lawyers who practice in front of the SEC. It's he described it to me as more than just head bottle washer because he has to make sure the popcorn is still out and still get on stage to introduce everyone. So it's a mammoth enterprise that he puts on, but it's something that I've come to appreciate. Bruce, the social media buzz on the day of the conference is just extraordinary. People are tweeting about it. I've read articles about it in various papers. So kudos to you for putting on really one of the signature events, and thank you very much for coming on the show again.
Thank you, Tom, and thanks for the kind words. It was a fun conference. It certainly has evolved a lot in 3 years, from just getting started to being, I think, quite a great conference in the securities enforcement area. And it's certainly not just me, involved in putting it on. There are a lot of people who put a lot of time and effort and thought into how to make it great, how to make it work well, who should be speaking and making the name tags and getting the popcorn, as you said. So it's a big effort and it's a lot of fun.
Well, Bruce, one of the things I've come to learn about securities enforcement and SEC is there's always some controversy or topic of interest going on, no matter what year it is, no matter when it is, no matter who the administration is, no matter who the players are. There's things to talk about. So I was just wondering if you might be able to talk about some of the highlights you heard and or saw in this year's conference.
Yeah, by the way, the conference is called Securities Enforcement Forum, and soon to be joined actually in May by Securities Enforcement Forum West, which we're going to hold in San Francisco.
Wow.
So that should be interesting, and maybe we'll see you out there, Tom. But yeah, it was an interesting conference. We had 6 different panels and 2 keynotes, and it started right from the beginning when Commissioner Michael Pivovar gave a very interesting speech. Just to give a little bit of context for it, the year before at Securities Enforcement Forum 2013, the keynote speaker, one of them, was Mary Jo White, the chair of the SEC. And at that conference, Chair White gave what is now known as her broken windows speech, in which she laid out a strategy and approach to enforcement. She had just kind of gotten on the job less than a year earlier, but she likened it to the approach that the NYPD took back in the 80s, I guess, when any broken window, any small violation, there was nothing too small. They would go after everything they could on the theory that if you go after everything, then you can kind of deter further crime. And so she likened that to her approach in the securities area and what she wanted to do in the enforcement world. 1 year later, almost to the day, Commissioner Pivovar appeared at our conference for 2014, and he took issue with what people have called the broken windows approach. And so what he said was that kind of approach may not achieve the results that the SEC is trying to achieve. And he made the interesting comment, if every rule is a priority, then no rule is a priority, which I thought was interesting. He made the point that regulatory compliance is not the ultimate goal. The goal is to enable and promote vital and vibrant economic activity. So, he's an economist. He has his point of view. It was in contrast to the view that Mary Jo White had given 1 year ago at the same conference. So that was interesting, and that prompted a lot of discussion. There's been a lot of discussion about the broken windows approach to securities enforcement even prior to that. And he also had some interesting points on an issue that I've written about through the years, which is the use of certain metrics to evaluate the effectiveness of the enforcement program at the SEC. What tends to happen, because it's easy to measure, is every year the SEC will say, oh, we had 600 enforcement actions. Oh, this year we had 650 enforcement actions. Oh, now we have 700. It's a record, and there's a focus on that. There's also often a focus on the amount of the monetary sanctions. It's $2 billion. Now it's $3 billion. Oh, now it's $4 billion. I guess the implicit message there is more actions are better and more money is better, which may or may not be true. But Commissioner Pivovar said it's time to measure outcomes versus outputs, I think is the way he put it. And he said, he gave the analogy, you would never measure the effectiveness of, say, traffic safety by looking at the number of tickets that were issued or the amount of fines that were gathered. And he was basically following up on some arguments that have been made, even by the SEC themselves. They've been really trying, I think, to de-emphasize pointing at the number of cases, because it really doesn't give you anything other than a very tiny snapshot of whether they've been effective or not. It's probably more effective to have one massive financial fraud case that sends a message to public companies than it is to have 50 failure to file on time cases. So the numbers themselves are not always the key thing to look at.
There was a very interesting article in the New York Times, the deal book section, about one of the panels where you had I think as high powered a panel as you could have in terms of former SEC high officials who are now in private practice. And they had several comments around the broken windows approach, about the SEC moving towards a greater administrative process, and finally, several of them had very large financial institution clients. And from the tone of the article was very different, probably, than the message they were trying to get across, because the tone of the article was, quit beating up on my banks. You're being too mean to us. Were you able to hear that panel, or have any thoughts on that?
I can't even imagine what panel or what article you're talking about, Tom. Let me think about this for a second. Okay, yeah, I think I do remember. So that's what we call the directors panel. This is the second year we've done it. It started off as kind of can you imagine if we could get all these people on one panel, and then it actually happened last year, and it was really popular, and I think the people on the panel even really enjoyed doing it. So we asked if they could do it again this year, and they did. And it really makes for a fascinating conversation when you have everybody from Stanley Sporkin, Bill McLucas, and so on, all the way through the current SEC Enforcement Director, Andrew Serezny. So it's great. So they got into a debate on the broken windows approach and whether it was the right way to go. They also had, as the author of that column, Jesse Eisinger, put it, and he said he felt like he was going into an alternate universe where, I guess in his normal universe, he's used to hearing people beat up on the regulators for not being tough enough on banks and not bringing enough cases. And then at this conference, he heard the past enforcement directors telling the current enforcement director, "You're being too tough. You're hammering our clients on this and that." And so, at least from his perspective, it was something that he wasn't expecting to hear. It was something different. I think that when you're in this practice area, the concept that the SEC is so lenient is not one that you're in agreement with. I think that's more of a kind of a public perception type of thing. But yeah, it was a great panel. I hope we can do it again in the coming years. In California, we try to do something similar. We got all the regional directors. So we had the current head of the SEC in San Francisco, the current head in LA, and the past 4 directors for those 2 offices. And we had a kind of a regional directors panel, which was also real interesting, with issues, I guess, somewhat focused on the West Coast, but also broader, getting their take on some national issues.
Bruce, one of the things that intrigued me about the article was the following, that with the directors panel, it seemed you had some very frank conversations, open and public record conversations by men and women who were involved at the highest levels of the Securities and Exchange Commission previously, and indeed Director Serezny was on the panel as well. But very open, very frank, a lot of give and take. It sounded like there were Q&A from the audience. Did I judge that right from reading the article?
Yeah, it's surprising. It gets to be an informal discussion between 6 people who have been at the very highest level of the SEC in the enforcement area, and it's a lot of fun to watch. And there are some real characters on that panel. Judge Sporkin is a very, very entertaining person to listen to. All those folks have insights that most people do not have, just based on what they've done and kind of the things that they've led. But yeah, I would definitely agree. It is kind of a freewheeling conversation, and it's great that Andrew Serezny is present, and he, I know he has a lot of respect for the folks that came before him, and that goes both ways, I think. But they have a kind of an honest and a interesting discussion, so it's definitely worth listening to.
For those listening to this podcast, if you're listening before October 31st, check my blog on Halloween, because I'm going to blog about the New York Times article. If you're listening after October 31st, go back and take my take on the article. It was a fascinating article, and I really couldn't wait to ask you about it on this podcast. But what else of note in your mind came up from the conference besides and beyond the directors panel?
Yeah, well, there were a couple panels that kind of went back to that administrative proceedings point. That had we talked about that already on this, or would we talked about that earlier?
You raised it in the context of the directors panel.
Yeah, well, there's been a recent kind of trend where the SEC brings more of its cases as administrative proceedings rather than what has kind of traditionally been a case brought in federal court. There have been some changes to the law in the last few years which allow the SEC to get penalties that they couldn't get before in administrative proceedings. And so in one of the first panels, Kara Brockmeyer, who's one of the SEC's unit heads for the FCPA unit, I'm sure you're well familiar with that, given your background, but she mentioned that bringing cases as APs, I think the way she put it was the new normal, and that may in fact be true. It's just been kind of a push to bring more cases, and the SEC has reasons that it is successful in those cases. It's kind of their home turf. It's their home field, if you will. Other people, there have been, as they've gotten more common, there's been more criticism leveled at the SEC and more people kind of pushing back, saying, well, these are significant cases you're now bringing as APs, whereas maybe you weren't bringing them big cases there before. But there are disadvantages to defendants, and the arguments are that these cases are expedited, so there's less time for people to be prepared and get the discovery they want. The federal rules of evidence don't apply. Federal rules of discovery don't apply, of civil procedure, I should say. So defendants, I meant to say the federal rules of civil procedure. I'm not positive about the federal rules of evidence. Maybe you are. Are you?
Well, I've only done ALJ administrative proceedings in front of the NLRB, and their
Okay.
rules of evidence did apply.
Okay. So, but what I meant to say was the federal rules of civil procedure are not in effect. The same discovery is not in effect. So there's been some pushback from people who are being brought into these courts, and there's been a lot written about it. And my friend Russ Ryan has written about it a lot recently. And the question is whether the courts may at some point kind of limit the things that can be brought as administrative proceedings. So that was real interesting. There were a lot of other highlights. Did you have something you wanted to add?
Yeah, I just wanted to follow up on that because I mean the SEC has used administrative proceedings for many, many years. And although I've never gone through that process, at one point in my career I was a labor lawyer and I went in front of the NLRB an administrative proceeding, a hearing, and they had an ALJ. And so one of the key reasons or uses for the NLRB was that you had a true dedicated professional who knew the National Labor Relations Act, he understood the issues, and really could bring a kind of a blue ribbon expertise to labor issues that were brought by the NLRB. And my sense is that that would be the same for SEC administrative law judges or ALJs. And indeed, in the first Hall of Fame class, I think you called it, there was a SEC ALJ.
Right.
So it would seem to me that you could have potentially a judge who precisely understood the security law issues in front of him or her, and that it might be a forum that defendants are more comfortable in.
Yeah, the judge you were referring to is Judge Brenda Murray, and Judge Murray was one of the 8 people that we, at the very end of the conference, we had a cocktail party, but we had a ceremony where we created what we call the inaugural class of the Enforcement Hall of Fame. And Judge Murray was one of those 8. I was very pleased to be able to honor her at that because she does a terrific job and she's very well regarded in the SEC world and the SEC securities enforcement world. But yes, so I think there is something very true about what you just said. The people who hear these APs are specialists in the securities laws. That's got to help in terms of getting things right. The counter argument is, well, the SEC gets to be, prosecution, judge, jury, executioner, they're everything, and it's too much home cooking. That's the way people argue against it.
What are some of the other topics of interest that came up at the conference, or things that just kind of piqued your interest?
Yeah, well, probably the most eagerly awaited event, and it was really, really fun, was a keynote by U.S. Attorney Preet Bharara from the Southern District. And it was in a really interesting format where he was on the stage in one chair, and then the only other chair was the recently outgoing Enforcement Director Rob Khuzami. So Mr. Khuzami served as the moderator for this keynote, and he and Mr. Bharara have worked together through the years at the SDNY, and of course probably worked alongside each other when Khuzami was the head of the Enforcement Division and working along with the SDNY. But that was fascinating. They're both very, very funny, very witty, and had a great rapport, having known each other for so long, and they could kind of joke with each other, and it just made for a very entertaining session. I don't know if it made a lot of news. It was real interesting, though. Mr. Bharara had some very interesting comments about, for example, when they're about to bring a case, say, against a corporation, and kind of the instant reaction that he often gets is, they invoke Arthur Anderson, and say, "Oh, this is going to be the death of the company. You can't do this." And his response is, "That's not true. We've done it many times. It's not, a death sentence. And be forthcoming, be forthright when you're coming in to talk to us, because we know what we're doing."
That's really interesting, because that's a great fear from the in-house side, that if there is an indictment against the company, and not just an indictment, but actually a trial and a guilty verdict, that could be the end. And I think many in-house practitioners are leery of that. I know the FCPA professor doesn't put a lot of stock in the Anderson effect. But being located in Houston and having lived through that, I put a little bit more stock in it. So, perhaps the answer is in the middle, or perhaps the answer is just every case and every company stands on its own, and the prosecution, based on the facts of whatever they might be. So I guess it's really hard to say one way or the other.
Yeah, I would say some other highlights were, for the first time we had some discussion about cybersecurity, which really wasn't an issue on anybody's radar screen that I was talking to 3 years ago, but is on everybody's radar screen now. That was part of a discussion about regulated entities, and we had the enforcement director from FINRA, Brad Bennett, on there. John Stark from Strauss Freeburg, who's an expert in cybersecurity, was on there, and got into that a bit, which was interesting. And then I really enjoyed the Hall of Fame ceremony a great deal. I mentioned Brenda Murray, but we also had being honored Ralph Ferrara, Roberta Carmel, who was the first female SEC commissioner, Gary Lynch, who everybody knows from his days as the enforcement director, but going after Michael Milken in that group. We had Bill McLucas, who's kind of a legend in the enforcement world, former enforcement director, Harvey Pitt, former commissioner, former general counsel of the SEC, Irv Pollock, the very first enforcement director, and Judge Sporkin, who's maybe the most legendary of all the enforcement people. But it was incredible to have 6 of the 8 present, and we got just a priceless photo of the 6 of them, including some great photos of Irv Pollock and Stanley Sporkin. It was really fun to watch, and I was really grateful that those folks were able to attend.
Well, I certainly enjoyed reading about that, and as I mentioned, one of the things that I enjoyed really the day of the conference was various people on social media, and Twitter was going full blast on what was being talked about, and then I have to kudos once again on the New York Times article. In my mind, it don't get much better than that.
Yeah, it's interesting to think about, the addition of a Twitter feed. It certainly wasn't something that I was able to really contribute too much because I was running all around. But 3 years ago, I don't think we had much in the way of a Twitter presence, and it was fun. People were different reporters and different people who were there covering the event or observing the event. A lot of bloggers like David Smith and Francine McKenna. I saw them online. Sarah Lynch from Reuters. It does add to the fun of the event. There was one thing that generated a number of tweets, which was probably a year ago. I read about this art exhibit called Elite Deviance, and so it was these 2 artists. Brad Cool and Monique Layton, and they created these 5 enormous canvases, and the art was made out of bookbinding tape. It looks like police tape. So it's these really brightly colored pieces of tape, but they made these amazing pieces of art about Madoff, Martha Stewart, Enron, and Stanford, Alan Stanford. And I think the 5th one was sold, so I didn't get to have one. But the artists are nice enough to ship this art to me, and we hung it up at the front of the conference. So it generated a lot of questions. What is that, and why is Martha Stewart up there in the front of the conference? But it was very interesting, and I thought it added to the day.
Well, and kudos to the city of Houston for having 2 of the 5. So we continue to be a hotbed of various types of enforcement.
Congratulations.
Yes, thank you. Bruce, we're nearly at the end of our time, but I wondered if anyone wanted to contact you about any of your comments or find out a little bit more about securitiesdocket.com, if they could email you with your email address.
Yeah, it's bcarton, like my name, BCARTON, at securitiesdocket.com. And if you haven't been to the Securities Enforcement Forum in D.C., I hope you'll come next year. If you're a West Coast resident, maybe come to the one in May, which will be at the Four Seasons in San Francisco on May 13th, 2015.
All right. Well, I'm definitely going to have to blog about that because it's really become one of the premier events in securities enforcement across the country. And like I said, the directors panel, and not only did what appeared to be incredibly informative, but frankly, it looked like a ton of fun.
It was fun. It was a very fun day. Hopefully, we can keep coming up with ways to keep it fun in the future.
Well, Bruce, thanks a lot, and I look forward to our next visit.
Thank you so much, Tom.